Case Law Number 71, 2024 AL, regarding the suspension of case resolution on the grounds that the matter has been resolved by the effective decision of the competent state authority, and is not within the jurisdiction of the CAA. Adopted by the Judicial Council of the Supreme People's Court on February 20th, 21, and 3, 2023, and promulgated together with Decision Number 119 QDCA, dated May 15, 2024 of the Chief Justice of the People's Court Supreme People. Source of the case law: Cassation Decision Number 14 of 2022 of DSGT, dated April 28, 2022, of the Supreme People's Court Council on the case, dispute over land use rights, and request for cancellation of the decision on complaint settlement of the People's Committee, between the plaintiff, Mrs. NGTH-H, and the defendant, Mrs. LUient T Sào. Related parties include 04 individuals. Location of the case law: Sections 3, 4, and 6 of the Court's finding section. Case law brief. Case law context: dispute over land use rights has been resolved by the effective decision of the competent state authority. The plaintiff continues to file a civil lawsuit regarding the disputed land use rights, and requests the cancellation of the decision that has been effective by the competent state authority. The plaintiff is not named on the land use rights certificate in dispute. Legal solution: in this case, the court must suspend the case resolution on the grounds that the matter has been resolved by the effective decision of the competent state authority, and is not within the jurisdiction of the court. Regulations related to case law: Clause 1, 2 Article 34 and Point C, Clause 1 Article 192, Point G, Clause 1 Article 217 of the Civil Procedure Code 2015, Article 38 of the Land Law 1993, corresponding to Article 136 of the Land Law 2003, Article 203 of the Land Law 2013. Keywords of case law: not within the jurisdiction of the court, resolved by the effective decision of the competent state authority, suspension of case resolution. Case content: in the initial lawsuit filed on December 8, 2014, and the supplementary lawsuit filed on May 18, 2015, the plaintiff, Mrs. NGTH-H, presented. Previously, the parents of Mr. Nguyen Tan T, her husband, deceased in 2007, were Mr. Nguyen TNK and Mrs. Tai TH-H1, who received the transfer from Mrs. La TH-S of an area of 20,000 hectares of rubber land, of which the area registered according to the 1973 cadastral record was 17,000 hectares. The unregistered area was more than 4 hectares. In addition, Mr. K and Mrs. H1 also received the transfer from Mrs. Ha THM of an area of more than 20,000 hectares of rubber land, of which the area registered according to the 1973 cadastral record was 17,000 hectares, and the unregistered area was more than 4 hectares. In 1975, Mr. K and Mrs. H1 registered the entire land area mentioned above with the local authorities. When Mr. K and Mrs. H1 passed away, Mr. T registered and declared the land, and was issued a land use rights certificate by the People's Committee of Q Commune and District, NG Nai Province on July 11, 1992. The entire area of land mentioned above has always been managed and used stably by her family. On December 8, 1987, due to the difficulties faced by Mrs. Nguyen THC's family, Mr. T allowed Mrs. C to temporarily cultivate about 2.5 sa unit of area, equivalent to 360 square meters, of land to grow flowers for economic purposes to support her family. During the cultivation process, Mrs. C encroached upon additional land of Mrs. H's family, and also built a solid house on borrowed land. Although the land dispute arose in 1992, Mrs. C inexplicably still managed to declare and pay taxes on it in 1993. On October 9, 1998, Mrs. C applied for a land use rights certificate. The area of land for which Mrs. C applied for a land use rights certificate was borrowed from Mrs. H's family for cultivation, located within the road boundary and disputed land, but somehow the Evaluation Council for granting land use rights certificates of Q Commune confirmed that the origin of Mrs. C's land was from Mr. T since 1987, and Mrs. C has used it stably and in accordance with the planning. On August 9, 2002, the People's Committee of N District issued a land use rights certificate to Mrs. C for an area of 2,526 square meters. On December 21, 2006, the People's Committee of N District reissued a land use rights certificate to Mrs. C for an area of 1,962 square meters of land. Mrs. H has repeatedly requested Mrs. C to return the entire plot of land mentioned above, but Mrs. C refused. Therefore, Mrs. H requested the court to compel Mrs. C to return the land to her. The defendant, Mrs. LUient T presented. In 1975, she moved from the countryside to the south to make a living in Q Commune, N District, Ng Nai Province. At that time, her family included herself, Mrs. LUient Th2, her younger sister, and Mr. LUient Ton L, her son. In the early days of making a living, she worked as a latex collector for the rubber plantation owned by Mr. LUient TNT. However, since her family did not have cultivated land and was given grassland, she cultivated flowers, sweet potatoes, beans, corn, etc., on the land currently in dispute. In fact, she and her family were not sure whose land they were managing. At that time, Mr. T lived in Ho Chi Minh City and occasionally came back to look after the land. He told her that the land her family was currently cultivating belonged to him, so she asked him for permission to use the land for cultivation, and Mr. T agreed. After Mr. T wrote the papers for the land, her family continued to manage and cultivate pepper and coffee on the land. In 1994 to 1995, Mr. T needed to expand the rubber plantation area, so he contacted the Commune People's Committee to invite households living on land adjacent to Mr. T's rubber garden to negotiate compensation. That includes her household, but her family did not agree to negotiate because, besides the land area mentioned above, her family had no other land area to cultivate. In 1995, Mr. T had a dispute with her. In 2000, Mr. T's family continued to sue her family to reclaim the land. On November 21, 2000, the People's Committee of District N issued decision number 1627, the QD, and on December 19, 2001, the People's Committee of District D issued decision number 4835, the QD rejecting Mr. T's complaint regarding the dispute over the land area given to her family in 1987. Therefore, she does not agree with Ms. H's request to claim the above land area. In decision number 55, 2018, a QDSTDS, on resolving civil cases dated October 31, 2018, the People's Court of Đường, Nai Province decided suspension of resolution of pre-approved civil case number 41 of 2015 of TLSTDS, dated October 14, 2015, on dispute over land use rights and request to cancel the decision to resolve complaints of the People's Committee between plaintiff Ms. Dang Thai Thu H, born in 1953, address 271 A10 Street, Ward X, District P, Ho Chi Minh City, Ms. H's authorized representative Mr. Sin Tai K, born in 1973, according to the authorization document dated December 22, 2014, permanent residence, 105 J Street P, Ward V, District G, Ho Chi Minh City. Contact address 244 Street B, Ward I, District T, Ho Chi Minh City. Defendant Ms. LUient C, born in 1939, address F3 113, Hamlet S, Commune Q, District N, Đường Nai Province. Persons with related rights and obligations. 1. People's Committee of Province D, address number 02 Street V, Ward T, City B, Dong Nai Province. 2. People's Committee of District N, Dong Nai Province, address. APL, Commune X, District N, Dong Nai Province. 3. Mr. Nguyen Ton L, address. F3 of 113, Hamlet S, Commune Q, District N, Dong Nai Province. 4. Ms. Nguyen Thai H2, address. F3 of 113, Hamlet S, Commune Q, District N, Dong Nai Province. Consequences of suspending the resolution of the case. The litigant has no right to sue and requests the court to resolve the civil case. The first instance court also decides on court fees, other procedural costs, and the right to appeal. On December 12, 2018, Ms. H appealed the decision to suspend the resolution of the above civil case. In the decision to resolve the appeal against the decision to suspend the resolution of case number 154, 2019, QDPT, dated May 8, 2019, the High People's Court in Ho Chi Minh City decided: accept the appeal of Ms. Dang Thai Thu H. Cancel the decision to suspend the resolution of civil case number 55, 2018, EQDS-TDS, dated October 31, 2018, of the People's Court of Dong Nai Province, and transfer the case file for the People's Court of Dong Nai Province to continue resolving the case according to the provisions of law. In the decision to appeal to the Supreme Director number 06/2022, the KNDS, dated March 14, 2022, the Chief Justice of the Supreme People's Court appealed to the decision to resolve the appeal against the decision to suspend the resolution of the case. Number 154, 2019, QDPT, dated May 8, 2019, of the High People's Court in Ho Chi Minh City, request the Council of Judges of the Supreme People's Court to conduct a cassation trial, annul the decision on resolving the appeal against the decision to suspend the resolution of the above case and maintain the decision to suspend the resolution of the civil case. Case number 55, 2018, EQDS-TDS, dated October 31, 2018, of the People's Court of Dong Nai Province. At the cassation trial, the representative of the Supreme People's Procuracy agreed with the appeal decision of the Chief Justice of the Supreme People's Court. Court's findings: 1. The area of 1,962 square meters of land the litigants are in dispute over is the land plot number 72, map sheet number 17, old plot number 56, map sheet number 12, map sheet number 17, in Commune Q, District N, Dong Nai Province. 2. In 1995, the above land plot had not been granted a land use rights certificate. Mr. Nguyen Tan T, Mrs. H's husband, had a dispute over the right to use a plot of land with 1993. 3. On November 21, 2000, the People's Committee of District N issued Complaint Resolution Decision Number 1627 QD.CT.UBH, rejecting Mr. T's complaint about reclaiming the land area of 2,152.15 square meters that Mr. T wrote a letter to Mrs. C on December 8, 1987. Disagreeing with this decision, Mr. T continued to complain to the chairman of the Provincial People's Committee D. On December 19, 2001, the chairman of the People's Committee of Province D issued decision number 4835, EQD.CT.UBT, to resolve complaints, with the content: recognizing decision number 1627, EQD.CT.UBH, dated December 21, 2001. November 2000 of the chairman of the People's Committee of District N on the resolution of Mr. T and Ms. C's complaints, is by the provisions of law, rejected Mr. T's complaint. 4. Thus, the land area that Mrs. H disputed with Mrs. Onion. 5. On August 4, 2002, Ms. C was granted a certificate of land use rights. On December 21, 2006, Ms. C was granted a new certificate of land use rights. 6. Therefore, the People's Court of Dong Nai Province suspended the resolution of the case according to the provisions of Point C, Clause 1, Article 192, and Point G, Clause 1, Article 217 of the 2015 Civil Procedure Code. senior citizens in Ho Chi Minh City annulled the decision to suspend the resolution of civil case number 55, 2018, EQDSTDS, dated October 31, 2018, of the People's Court of Dong Nai Province and transferred the case file to the court. The People's Court of Dong Nai Province continuing to resolve the case according to the law is unfounded. For the above reasons, decision, pursuant to Point A, Clause 2, Article 337, Clause 2, Article 343, Article 344 of the Civil Procedure Code, 1. Accepting decision on Cassation Appeal Number 06/2022, the KNDS, dated March 14, 2022 of the Chief Justice of the Supreme People's Court, 2. Cancel the decision to resolve the appeal against the decision to suspend the resolution of the case number 154, 2019, QDPT, dated May 8, 2019 of the High People's Court in Ho Chi Minh City regarding the case, dispute over land use rights and request to cancel the complaint settlement decision of the People's Committee, between the plaintiff, Ms. Dang Thai Thu H., the defendant, Ms. Nguyen Thai C., and people with related rights and obligations. Other officials, 3. Maintain the decision to suspend the resolution of civil case No. S5, the 2018, QDSTDS, dated October 31, 2018 of the People's Court of Dong Nai Province. Contents of the law. 3. On November 21, 2000, the People's Committee of District N issued complaint resolution decision number 1627, AQD.CT.UBH, rejecting Mr. T's complaint about reclaiming the land area of 2,152.15 square meters that Mr. T wrote to Ms. C on December 8, 1987. Disagreeing with this decision, Mr. T continued to complain to the chairman of the Provincial People's Committee. On December 19, 2001, chairman of the Committee People's Committee of Province D has decision number 4835, AQD.CT.UBT, to resolve complaints, with the content, recognizing decision number 1627, QD.CT, dated November 21, 2000 of the chairman of the People's Committee District, and regarding the resolution of Mr. T and Ms. C's complaint in accordance with the law, rejected Mr. T's complaint. Thus, the land area that Ms. H disputed with Ms. C has been resolved in decision number 4835, OQD. CT.UBT, dated December 19, 2001 of the chairman of the People's Committee of Province D takes effect. 6. Therefore, the People's Court of Dong Nai Province suspended the resolution of the case according to the provisions of Point C, Clause 1, Article 192, and Point G, Clause 1, Article 217 of the 2015 Civil Procedure Code. People's Court in Ho Chi Minh City annulled the decision to suspend the resolution of civil case number 55, 2018, EQDSTDS, dated October 31, 2018 of the People's Court of Dong Nai Province, and transferred the case file to the court. The People's Court of Dong Nai Province continuing to resolve the case according to the law is unfounded. Thank you for watching.